Welcome to this presentation. This will be our second lecture on Chapter 9. The name that our textbook gives to Chapter 9 is Your Responsibilities as a Hospitality Operator. The name that I prefer for the chapter is Torts Chapter because that's really what this chapter is about. So let's get restarted on the material. These are the 5 goals that we have, or the 5 topics that we'll be covering in this chapter. In our first lecture, we talked about the duties and obligations of a hospitality operator, and we also talked about the theories of liability. In this lecture, we're going to continue on. We're going to talk about legal damages, also the anatomy of a personal injury lawsuit. And by the way, the anatomy of a personal injury lawsuit is pretty much just the anatomy of a civil lawsuit. There's really not a lot of specifics that we see relating to personal injury that wouldn't occur in any other type of civil lawsuit. And then we'll conclude with talking about how to respond when an incident, an accident, an emergency arises in your hospitality business. What are some strategies to increase the odds of a good outcome as well as reduce the risks of legal liability? So let's go forward from here. So here we're going to talk about legal damages. There's lots of different ways of dividing up the topic of damages, and if you read different textbooks, they'll have different ways of looking at it. This textbook, because I guess we have such little time to talk about this topic, has decided to be very minimalistic, which is perfectly fine for this particular course. And they've really decided that there are kind of 2 buckets of damages that we have. One is compensatory damages, and you can see in the name they're designed to compensate or to make the plaintiff whole or to return the plaintiff to the condition he or she was in prior to the injury. Those are ideas that we see when we're talking about compensatory damages. There are things like what out of pocket is the particular plaintiff out because of this particular injury? What are his or her medical expenses, lost wages, pain and suffering, things along those lines. The one thing compensatory damages does not include are attorney's fees. The plaintiff will need to pay for his or her own attorney out of his or her own pocket. So attorney's fees are not a category of damages that are ordinarily compensable under tort law. Attorney's fees, here we go. Fees. Another category that can be important in the right case are punitive damages. And you can see in the beginning of the word punitive, we have the word punish. In fact, many times legal professionals refer to these as punies. They are designed both to punish and also to deter. So another term that you'll sometimes see for punitive damages is exemplary damages. We're making an example out of somebody. And by making an example of that person, we might be deterring either that particular person from engaging in that behavior again, or other people who will be aware of what that punishment has been. So it changes perhaps business practices. So when are punitive damages or exemplary damages usually available? In a tort case, typically they're restricted to cases of intentional torts or sometimes gross negligence situations. They are not usually going to be applicable in strict liability cases unless, again, there's also the gross negligence situation, or in normal negligence cases. So most tort issues don't involve punitive damages. A challenge, though, when you are the defendant in a tort case is that very likely the plaintiff has asked for punitive damages, and you can't be 100% sure, at least in some cases, that the jury might not conclude that there was, in fact, gross negligence, and that would open you up for punitive or exemplary damages. And so as you consider your settlement posture, you may well think to yourself, well, I cannot rule out the possibility that punitive damages could be in play in this particular case. Punitive damages are different than compensatory damages because, as I said before, the goal of compensatory damages is to make the plaintiff whole, to return him or her to the condition that he or she was in just immediately prior to the tort. But punitive damages are a windfall. This is money up and above what the plaintiff would have otherwise been able to get. The plaintiff is actually out ahead of the game, is better off financially than he or she would have been if the tort had never happened. So you may be thinking to yourself, well, that doesn't sound quite right. Why should the plaintiff be happy that he or she was the victim of a tort? That doesn't make a lot of sense. There are people who think that punitive damages should not be, while they may be appropriate for the defendant to be charged with, but they shouldn't be an amount of money that the plaintiff receives. Perhaps they go to the state, for example. That could be a way of handling punitive damages. While there's a certain logic to that, since this is really not money that the plaintiff is out, most jurisdictions, well, as far as I know, all jurisdictions, and including Texas, do allow the plaintiff to keep the punitive damages. And part of that is just for practical reasons. If we move to a system in which punitive damages went to the state instead of the plaintiff, most plaintiffs would not be interested in suing about punitive damages because they're not going to benefit from it. They might be concerned if they do sue for punitive damages that they might find that the jury awards more punitive damages and less actual or compensatory damages. And so the plaintiff might actually earn less money as a judgment than if he or she hadn't requested punitive damages at all. It would also make settlement much more difficult because now the state is a participant in the lawsuit, and so the state, since the state is entitled to the punitive damage portion of any award, the state would be in a position perhaps to interfere with or slow down the process of settlement talks. So for those reasons, and there's others as well, but those are the main reasons that we've allowed the plaintiff to keep the punitive damages, even though it's not technically a damage that he or she is experiencing. Let's look at the term personal injury. This is really just another term for torts. A tort is a personal injury. In fact, attorneys who represent plaintiffs in tort cases are oftentimes called personal injury attorneys. That's the term for them. So basically, a personal injury is a tort type injury. The textbook chooses to define the term a little bit differently. It talks about damage or harm inflicted upon the body, mind, or emotions. So you could say that a person experiences a personal injury even in a non-tort situation. But as a practical matter, that's not how these terms are used. People use in the legal business, they use personal injury, this term, to refer to tort damages. Most personal injury claims are going to be the negligence claims, are not going to involve intentional or strict liability claims, but in theory they could. So again, this definition is a little bit too broad for how this term is actually used in the real world. Personal injury is another way of describing tort in the law. Okay, so now we are done with legal damages. We just have two to talk about here. Now we're going to talk about how a lawsuit is structured. And what I'm about to say, again, is going to apply to a breach of contract case, a tort case, a statutory case, really any type of case that isn't a criminal case. And we're going to break up the personal injury lawsuit into four components. Actually, it would have been this is the way the textbook does it, and so it's perhaps a useful way of doing it, but it's by no means the only or even the best way of dividing up this material. The textbook starts by talking about a demand letter. In the area of tort law, in most cases, a demand letter is going to be optional. The plaintiff does not have to send the demand letter to the defendant. Even though it's optional, it is a good idea to send a demand letter. It's a relatively inexpensive thing to do, for one thing. After all, sending a letter isn't going to be very expensive. And it alerts the defendant to the possibility that he or she may be sued. It may be the first time the defendant even knows about the claim. Typically, a demand letter is going to be prepared and signed by a law office, so an attorney will be signing the letter. And even if the defendant was aware that there was a possibility that the lawsuit could be filed, now he or she knows, wait a second, this person has actually hired an attorney. And so many times that kind of increases the level of seriousness that the defendant is going to approach this particular matter. It also invites the defendant to explore the idea of settlement. When you make a demand letter, you're basically demanding or requesting that the case be resolved short of litigation. And you're saying, well, you know what, if you don't settle, I'm going to go ahead and sue you. So the term demand letter is kind of a strongly worded term. And a letter that is a demand letter should be strongly worded. I mean, you're trying to persuade the person that that person is at significant risk in the case of litigation. But it is also an attempt to settle the case. So there's a careful balance between being strong and firm, but also being problem solving and looking at ways of settling the case. So that's the first part of the process. And I think I have a definition here. Official notification. This is again from the textbook. I don't know that official is exactly the right word. There's no office or officer involved in it other than an officer of the court, which is what every attorney is. It's typically delivered in some way to the defendant or to the defendant's attorney if the plaintiff knows that the defendant is already represented by an attorney in this matter. The textbook will say that it's oftentimes sent certified mail or registered mail, and that's certainly fine to do, but a demand letter doesn't have to be sent that way. And basically what it does is it explains the plaintiff's case and invites settlement. It's demanding that the defendant do something, or saying, and what will happen if you don't is we'll file the lawsuit against you. There are some times in some jurisdictions where a demand letter can be required. Since most of tort law is a common law, most torts don't require a demand letter. But again, even when it's not required, it can be a helpful strategy. So that's the first step. And again, it's kind of an optional step. But the next step isn't optional. And you're going to follow this step if the demand letter hasn't been successful. And I'll be honest with you, most demand letters aren't successful. It's a relatively inexpensive tool. So it's okay if it only gets you results 5 or 10 or 20% of the time. So as you, the plaintiff, the next step you're going to do is you're going to file either a petition or a complaint. In Texas, we call the first document filed by the plaintiff in the lawsuit a petition. But if we're in federal court, we call it a complaint. Even though there's different names, they are essentially the same document. They're very similar in terms of their content. Both names make sense. Let's just look at what a petition is. When we make a petition, we are requesting something. And so a petition is a request to the court, solve my problem. Your Honor, please make that other side pay me this amount of money. So when we use the term petition, we're focusing upon our request to the court. A complaint is also a request to the court, but it's not focusing on what the court what we want the court to do, but it's saying we are complaining about what the defendant has done to us. Now, implicit in that is the request, solve our problem. But you can see both of these terms are kind of logical names for this document. And the word complaint, we see the term, the beginning of the word plaintiff. You can see if I write the plaintiff. And so complaint kind of has a logical connection with the word plaintiff. This is the first pleading. Many people call this stage the pleading stage in a lawsuit. So after the defendant has filed his petition or his complaint, whichever is appropriate for the particular court he or she is in, the defendant in most cases will file an answer. That's the name of the defendant's pleading. And then after all the pleadings are filed, then we're going to go to the discovery phase. There's actually more pleadings that can be filed, and there's more options that the defendant has other than filing an answer. So this is kind of a stripped down explanation about this process. Before we go any farther, let's talk about how attorneys are paid when we have a personal injury lawsuit. Let's first of all talk about it from the perspective of the plaintiff. So let's say that the plaintiff comes to see a plaintiff's attorney and says, I've got a beef against, ABC Hotel or ABC Restaurant or whatever. The first thing that is going to be an issue for the plaintiff's attorney is, do I want to take this case? Is this a case that interests me? Is this a case that fits the business model I have for my firm? And is this case going to make me money? Most likely. Those are the decisions that are kind of in play here. Attorneys are business people. At the end of the day, they want to make money. They want to be successful in their practice. It is true that attorneys do sometimes take cases on a pro bono basis or on a volunteer basis, and sometimes they even take cases for fees when they really ordinarily would look at the case and say, this is not a moneymaker for me. But most of the time, because they're not charities, they're going to be looking at their bottom line. And so before even a demand letter is written, the law firm has to decide, is this a case worth taking? So how does a plaintiff's attorney approach this issue? Well, the first thing to keep in mind is, how is a plaintiff's attorney compensated in a tort type litigation? The vast majority of plaintiff's attorneys are compensated on a contingency fee basis. It's not the only structure, but it is by far the most common. Think about it. You're a plaintiff. You've had something bad happen at a hospitality facility, or, well, any other tort. It doesn't have to be a hospitality case. In most cases, you don't have a lot of money. For one thing, most people just generally don't have a lot of money. And certainly after you've been the victim of some kind of tort, you're likely to have less money. You've probably had some kind of medical bill or some lost wages or something along those lines. So you probably didn't have thousands of dollars to spend on an attorney before this tort happened, but you definitely don't have it now. In fact, one of the reasons you may be seeking an attorney is because you don't have money to pay some of these bills. So a structure like an hourly fee structure is not going to work for most plaintiffs' attorneys. For most plaintiffs. Now, of course, Bill Gates can be the victim of a tort, and certainly he would have lots of money. So there are certain plaintiffs who have a lot of money who can possibly pay an attorney on an hourly fee basis, but that's not something that is available for most plaintiffs. So we have an alternative system in the United States for payment under those circumstances, and we call it a contingency fee arrangement. In this scenario, the attorney isn't paid based upon the number of hours that he or she works for the plaintiff. Instead, he or she is paid on a contingency. It's paid based upon what actually happens in terms of how the case is resolved. So basically what a plaintiff does is he sells a portion of his lawsuit to the attorney. He says, listen, attorney, I will give you 20 or 30 or 40% of whatever I recover out of this case in exchange for you providing legal services to me. So let's say that the plaintiff is able to win a judgment or a settlement at $100,000. Now let's say the contingency fee arrangement that the plaintiff has negotiated with the law firm is a 30% contingency. Well, that means that the law firm is going to get $30,000 and the plaintiff is going to get $70,000. Now these are gross amounts. Obviously there's taxes involved, but that's how the gross amount would work. And this can be either via settlement or through a judgment. It's not unusual for a contingency fee arrangement to have a variety of percentages. For example, when you're looking at the demand letter stage or the pre-lawsuit filing stage, you might have a relatively small amount like 20%. Once the lawsuit is filed, that percentage might go up to 30. Once you go to trial, that percentage might go up to 40. So you have a lot of range of numbers at some point. And so this isn't necessarily a static number. But let's say this case goes forward and the defendant isn't willing to settle. You go to trial and you know what? The jury just didn't buy your case. It awarded you zero money, awarded the plaintiff zero money. Well, under those circumstances, the attorney gets 30% of zero, which, as you probably know, is zero. So the attorney has spent hundreds, perhaps thousands of hours preparing this case, and yet he is getting no compensation. So sometimes that happens, or sometimes there's only a very small amount of compensation. Obviously, the plaintiff doesn't want to have, the plaintiff's attorney doesn't want that to happen on a regular basis. So before he selects a case, he looks at it. And the things that he looks for are these. Number one, he looks to see, are there significant damages in the case? Even if there's clear liability on the part of the defendant, if the damages are only $10,000, you can see how 40% of $10,000 is $4,000. That's not very much money. Unless the case is going to settle almost immediately, that's not economically appealing to the plaintiff's attorney. So want to have significant damages. The second thing that the plaintiff's attorney wants to see is clear liability on the part of the defendant. Sometimes the case is clear. The defendant was legally drunk, the defendant was cited, the defendant rear-ended the car. There can be situations that you can look at and go, yep, okay, that's a pretty clear liability, pretty darn good chance that we'll be able to persuade the jury that the defendant is culpable. Then there are other cases where it's open to more than one interpretation. Maybe your client didn't do everything exactly as it should have been done, or maybe there's a factual dispute about what exactly happened. Well, now there's a greater chance that the result may be 0. And of course, that's not a very happy place, either for the plaintiff, of course, or for the plaintiff's attorney to be in. So you want to see, as a plaintiff's attorney, you want to see significant damages and clear liability on the part of the defendant. But those two things aren't enough. You want to see a third thing, and that is you want to see that the defendant has the ability to pay. Usually corporations of significant size are going to have that ability to pay. And if a corporation doesn't have that, then you're looking for insurance that's going to kick in. There's no benefit to suing an entity even when there's significant damages and the entity has obvious liability if that entity doesn't have any money. Just as a waste of time for everyone. So you want to see those three things. And so as that plaintiff goes to a law firm, those are the types of questions that the law firm is going to ask before the law firm accepts the plaintiff's case. So that's how the contingency fee arrangement works out. This is the most common method for plaintiff's attorneys to use in order to be compensated. But you can see how there's some significant downsides. Obviously, for one thing, you could do all that work and get paid 0. Another problem has to do with cash flow. You accept a case on Monday, you might not see any money for years out of that case, and yet you're having to hire and pay your secretaries and your paralegals and your other attorneys in your law firm for that period of time until payment is received. So there's oftentimes some cash flow issues in plaintiffs' law firms. As a result, and also plaintiffs, on the other hand, they also want to get money sooner rather than later. Sometimes a little bit of money now is worth significantly more than a lot of money that they may be able to recover in a year or two. As a result, sometimes plaintiffs' attorneys and plaintiffs are very motivated to settle early on. The defense side is very different. Typically, a civil defense cases, especially in the tort area, your defendant is going to either be the insurance company or the corporation. Relatively deep pockets here. And of course, there's no possibility of a contingency fee under this circumstance because the defendant is not going to earn any money no matter what the result is going to be. So there's no possibility of some payment to the defendant unless, of course, the defendant has some kind of counterclaim. As a result, defense attorneys almost always bill their time on an hourly basis. And so in that sense, the defense attorney, his or her motivation is a little bit distinct from the plaintiff's attorney because the defense attorney isn't really focused on, well, what are the damages like? What's the liability like? His greater concern is this client going to be able to pay my bills? So that's how the fee structure works. Because you will be in the role of the defendant in these civil cases, it's very likely that you would be paying the attorney representing you and your business on an hourly basis. So now we're going to talk a little bit more about petitions. I think we've pretty much covered most of it, but let me just make sure. The petition or complaint is a document that the plaintiff files to begin the lawsuit. We talked about the difference between the plaintiff and the petition and the complaint. By the way, this is information that isn't available in your textbook because obviously your textbook's a national textbook. So be sure to note this. You are responsible for this information. Now we're going to go ahead and talk about the third item on our list, and that is discovery. Discovery is, in many people's opinion, well, I guess the first thing to say is it is just factually true that it's the longest part in the lawsuit. And many people think it's the most important part of the lawsuit. It's an aspect of our legal system that's rather unique to the United States. Many, many countries don't have discovery at all, or they have a much more limited type of discovery. There are advantages and disadvantages to discovery. Some of the disadvantages are that lengthens the trial process, and it is very expensive for both the plaintiff, but especially for the defendant. So those are two downsides to discovery, but there's some positive sides too. Discovery involves, as you can hear in the name, both sides are sharing the information that they've discovered in the lawsuit. And so you really don't see trials by surprise in our civil system. They're almost like well-acted plays because both parties, both the plaintiff and the defendant, know exactly what the witnesses are going to say because they've already heard it before. The only people who are seeing this play for the first time are going to be the jury and the judge. And so as a result, there really are not a lot of surprises. And that's one of the reasons why we have that system. The idea is, and this isn't actually how it works out 100% of the time, but there's some truth to it, is the goal is to remove some of the skill aspects and in the hopes that the jury will be in a position to evaluate the truth of the parties, irrespective of how skillful the attorneys might be. Another advantage to discovery is that sometimes one party, especially the plaintiff, might not have been able to get the information despite his or her best efforts. That information, if it was under the control of the defendant, it would have made it impossible for the plaintiff to be able to get that information. And so therefore, the jury never would have heard that important evidence that might have caused the jury to rule on behalf of the plaintiff. We usually think in terms of there being 5 discovery tools, and these are interrogatories, requests for production, depositions, mental or physical examinations, and requests for admission. We see in the textbook that the textbook focuses upon this first one and the third one. I'm going to talk in a little bit more detail about all 5, just so you'll have a point of comparison. An interrogatory, we can see in that term the beginning of the word interrogate. We all know to interrogate is to ask questions. These are written questions that the other side has to respond to, typically within 30 days, and they have to respond to the questions under oath. They also have an obligation to investigate or research the answers. As a result, this can be a very expensive and very time-consuming process. Literally, the defendant can spend thousands of hours and sometimes tens and even hundreds of thousands of dollars getting this information. So it's not a trivial situation by any means. Oftentimes with interrogatories, the parties will also make requests for production. They can be requests for production of documents, they can be requests for production of data, or even physical items. So when we say production here, we don't mean that you're creating stuff. It means you are producing or showing these items to the other side. And so the amount of data that is exchanged in lawsuits has dramatically changed since I started practicing law in 1990. When I started practicing, you might exchange 2 or 3 or 4 banker's boxes in a simple torts type case. And now the amount of data that you might exchange might fill a whole room, a whole classroom with paper if it were all printed out. As a result, the collection of this data can be fabulously expensive, fabulously time-consuming, and the production itself can actually result in more expense than what is actually at issue in the lawsuit. So many times these are done together because the question might say, tell me all about X, and then there might be a related request for production that says, produce all the data relating to X. These first 2 tools are relatively inexpensive for the asker to ask, but can be quite expensive for the responder to respond to, especially if it's a large corporation. After the parties have gone through the interrogatory request for production stage and have had an opportunity to review the data and kind of process it, oftentimes the next step are depositions. Depositions are in some respects very similar to interrogatories in that they are questions in which the party or the individual answers under oath. But there are some important differences between depositions and interrogatories. For one thing, depositions are oral questions, and the answers are also oral. They're answered in real time. As a result, the deponent, or the person answering the questions, doesn't have to research, in fact, can't research the answers. He or she just has to answer to the best of his or her knowledge. So it's not that the person is going to go away and say, wait a second, I don't have that data with me, let me go run to my office and find the answer. No, that's not how depositions work. Another difference between interrogatories and depositions is that you can only interrogate through interrogatories parties to the case, either the plaintiffs or the defendants. But with depositions, you can depose anyone who is a witness in the case, even if they are not a plaintiff or a defendant in that particular action. A third important difference between interrogatories or depositions is that while the parties are required to respond to the interrogatories and requests for production, as a practical matter, it's the attorneys and paralegals who prepare and sort and process this information. So the documents are quite lawyered up at the end of the day. But a deposition involves the oral testimony of the actual witnesses. It's the same testimony that they'll give in court. And some people are really good at it, and they can be coached and trained how to be effective, and some people are just not good at all, and they aren't very coachable. And as a result, the attorneys really can't control that answering process nearly as much as they can with interrogatories. Through depositions, sometimes you will find out facts that the attorneys were working pretty hard to minimize or to diminish the significance of. So it can be a very helpful thing. But even more probably than facts is that you get to see the deponent and see his or her personality, how he or she responds to questioning. Is this somebody the jury's going to like? Is this somebody the jury's going to believe? Is this somebody the jury's going to find arrogant, confrontational, unpleasant? Those types of things are tremendously important in deciding how to prepare your case and whether and how much you ought to settle the case for. Another tool that is often used are mental or physical examinations. These aren't permitted in every case, and they're usually just going to happen of the plaintiff. The plaintiff is alleging maybe some injury. Maybe they fell down a flight of stairs in your hotel. And let's say that they are claiming chronic back pain as a result of the accident. Well, you may challenge that. You may think, well, we want our own doctor to evaluate whether this is really a case of a serious injury or whether this person might be exaggerating his or her symptoms. And so that would be a classic situation where you might order a physical examination. And then the plaintiff at trial would present his doctor who would say, oh yes, this is all legit. This person really is in a lot of pain, and this is how I know this person's in a lot of pain. And then the defendant could present his doctor who says, no, or not his personal doctor, but the doctor that he has hired for this purpose says, no, this person's exaggerating. They're not in that much pain. And then the jury would be the final decision maker about really what's going on in this particular situation. Not every case is this appropriate for. Obviously, if it were a case of defamation or ruining a person's reputation, there's not going to be any physical or mental injuries. Also, you typically don't see a physical examination when it's uncontroversial what happened. Somebody fell down the stairs and broke his arm. Well, there's x-rays. It's pretty obvious that the arm is broken. Well, why would you need to hire your own doctor to make that judgment when it's a clear-cut situation? Let's say the arm was broken, it healed normally, there's no residual pain. Well, that would be a case where the defendant probably would just agree that, yeah, well, what the doctor says is what we think happened because it's what happened. So you only are going to seek a mental or physical examination when there's some controversy associated with it. And if you do seek a mental or physical examination, you probably will want to have a deposition for that particular doctor of the other side so you can find out what he or she might say. And then finally, we have our last discovery tool. And the reason that it's last is it's usually the last step that is taken. And this is when we make a request for admission. We ask the other side, hey, do you admit these particular facts? And when the other side has to answer under oath, either that they admit them or that they deny that particular fact. This can be very helpful in narrowing the issues for trial. Let's say, for example, that Bob was driving a car and Sally was driving the other car. Well, the request for admission might be, do you admit that Bob was driving the Toyota Corolla that was left bound on Legacy Drive at approximately 1:30 p.m. on June 14th, 2017? Well, that's probably not controversial. Probably the other side's going to say, well, yeah, I mean, that's when the accident happened. That's where the accident happened. That was how the car was traveling. That's the type of car that was traveling, and that's who was driving the car. We agreed to all that. But let's say that they dispute one of those particular aspects. Well, this would be a good opportunity to figure, wait a second, they're not sure Bob was driving, or they're not sure it was a Toyota Corolla that was involved in the accident, or they're disputing whether the direction Bob was going on the road, or they're disputing the date or the time. And so that can help you see what you think isn't controversial. You can see maybe where the controversy is. It can also streamline the trial. We want to be as kind as possible to the jurors and make the trial as efficient as possible. So you don't want to get bogged down in silly proof, proving things that everybody can agree to. The jury gets bored, the jury gets frustrated, the jury doesn't like that. And so you want to streamline as much as possible and remove the things that aren't controversial to the case. So these are the 5 tools that are used in discovery. And again, here's the definition of interrogatory: questions that require written answers given under oath. They're sworn statements. And then we also have depositions. Again, these are oral questions, again, under oath. And they are questions asked. A court reporter is going to be there to actually take the deposition. Many times they are videotaped. They don't have to be videotaped. Process. A subpoena is a court-authorized order to appear at a particular time and place, and also it can be to produce certain evidence. A subpoena literally means in Latin under, which means sub, like subway or submarine, and pena means under penalty. So if you don't comply with the subpoena, you could be under penalty. You could be held in contempt of court by not doing what you're supposed to do. As part of the discovery process, it's pretty common for documents to be subpoenaed so that evidence can be developed. Also, witnesses can be subpoenaed to appear at trial. Okay, so we would have a trial, obviously, after the discovery process. Let me go over briefly what a trial, how that proceeds. Typically, the first thing that happens is you sit the jury. You select people from the panel to actually belong on the jury. Both sides have the opportunity to challenge jurors who might have a particular prejudice that would make it impossible for them to fairly hear the case. In addition, both sides have peremptory challenges where they can say that they want certain jurors excluded simply because they just don't think they would be a good match for the panel. Once a jury is seated, then the plaintiff goes first. The plaintiff goes first for 2 reasons. First of all, he bears the burden of proof, and so it makes sense that he gets to go first. It's kind of a strategic advantage. Secondly, he's the person with the beef. It doesn't make sense to have the person who doesn't have the beef go first, because what was he going to say? His job is to respond to what the plaintiff is saying. So the plaintiff goes first and makes an opening statement, and then the defendant goes and makes his opening statement. Many people consider this part of the trial the most important part of the trial. Even though jurors aren't supposed to do this, in many cases the jurors kind of have decided what they want to do with the case based upon what they hear in the opening statement. After the opening statement is concluded, then the plaintiff presents his or her witnesses. It will call the first witness and ask him questions, and then the defense side gets to cross-examine that witness. And occasionally the plaintiff might have additional questions after the cross-examination. So all of the witnesses that the plaintiff wants to present are presented, and through their witnesses they get to put documents and other evidence into the record so the jury will have access to that information. After the plaintiff has completed with all of his evidence, then the defense gets to call its witnesses. And again, same process. It calls a witness, asks the witnesses questions, then the plaintiff gets an opportunity to cross-examine the witness, and then the defendant can ask any additional questions it might have. And again, through this process, the defense gets to put into evidence any documents that those witnesses would be able to validate. Okay, so after the conclusion of the plaintiff's case and the defense case, then the plaintiff makes its closing argument. It's the last opportunity for the plaintiff to kind of present his side of the story. And then the defense makes its closing statement. sometimes and now it's time for the judge to make its jury charge or jury instructions. And so the jury hears how, first learns what the law is, and then the jury it starts its deliberation to decide how it's going to decide the case. If it rules in favor of the defendant, then the case is over. It's pretty straightforward. The plaintiff doesn't get any money. But if it decides that it's going to rule in favor of the plaintiff, it also has to decide the damages that the plaintiff is going to receive in this case. Once the trial is over and the jury has returned its verdict, then the party who lost has to decide, am I going to appeal this decision? Well, what is an appeal? It's a written request to a higher court. Of course, we're in a trial court is the first place, so the Court of Appeal would be the next place to go, to modify or reverse the decision of a lower court, and that would include the decision of that jury. In all cases, the loser in a lawsuit has an opportunity to appeal that decision. About 10% of cases are appealed, and about 10% of appeals are successful. So there's really just about a 1% case that a case will be overturned on appeal. Appeals are usually not about criticizing what the jury has done. Appellate courts are reluctant to find that the jury made errors because, after all, the appellate court wasn't there in the courtroom. They didn't hear the live testimony of the witnesses, so they weren't in a very good position to judge things like credibility. Instead, the appellate courts focus on errors of law. Did the judge exclude a piece of evidence that he should have allowed in? Did the judge allow in a piece of evidence she should have excluded? That type of thing is usually the route that we see appeals take. At trial, the plaintiff bears the burden of proof, as I said. In a civil case, the burden of proof is called preponderance of evidence, of the evidence. This means that the plaintiff's version is more likely to be true in the minds of the jury than the defendant's version. But it's not a very heavy weight of a burden of proof. It's only more likely than not. So if the juror says, well, you know what, I found both stories pretty credible, but I think the plaintiff's story is just a tiny bit more credible, then that juror ought to rule in the plaintiff's favor. But if the juror finds the defendant's story is just a tiny bit more credible, then that juror ought to rule in favor of the defendant. If the juror decides, you know what, I just don't have any leaning one way or the other, I found the plaintiff's version as credible as the defendant's version. So it literally is a 50-50 situation. Well, under that situation, the plaintiff has not borne its burden of proof, and so therefore the jury needs to rule in favor of the defendant. We haven't discussed the most common way that disputes get resolved in the United States, and these are what we call ADR, Alternative Dispute Resolution. When I see the word alternative, I think to myself, well, this must be kind of an unusual, not the standard way of doing things. But in fact, ADR is the usual way disputes get resolved in the United States. Studies indicate about 97% of lawsuits that are filed don't go to trial, or that they get resolved before trial time. And two common ways that they get resolved are through mediation and arbitration. Certainly mediation is the more common. And this is a method of resolving a lawsuit without actually going to trial. What happens in mediation is the two parties sit down, sometimes in the same room, sometimes in different locations, and a mediator tries to persuade the parties to resolve their dispute. A mediator is a disinterested party. He's not on the plaintiff's side, he's not on the defense side. Typically, he's an attorney, but he doesn't have to be. And also, he's knowledgeable about the particular area of law that this dispute has arisen in. He's going to listen to both sides, and he's going to try to, or she's going to try to develop credibility with both sides. And then he or she's going to explain to both sides, oftentimes confidentially, what he or she sees as the problems in the case. Well, you know, these are the good facts you have, but these are the not so good facts that you have, and these are some things you ought to think about. You might lose if you don't settle the case because of these facts. The idea here is that the mediator is being able to be an objective voice, and that he's going to have credibility with both sides. So the hope is that the case will settle as a result. But the mediator doesn't have any ability to force the parties to settle. So if one or even both parties doesn't want to settle, or it has an unrealistic expectation of what settlement's going to look like, then the case won't settle despite the best efforts of the mediator. So that's mediation. Virtually all litigation, except for maybe small claims court, before it goes to trial, will have gone through some version of mediation. Of course, there can be another, it's like mediation, but kind of mediation without a mediator. We call that negotiation. And that is, always going to happen, essentially, in something that is outside of small claims court, where the parties amongst themselves try to settle the case. And many times the judge will try to act as a mediator. Another important type of ADR is arbitration. Now, the judge can force parties into mediation or into negotiation, but the judge can't force people into arbitration. This is a system that's an alternative to the court system. And in this system, instead of using a judge and a jury, you use an arbitrator to resolve the case. And typically, arbitration is binding, although it doesn't have to be. And when I say binding, I mean that the parties are going to be stuck with whatever that result that the arbitrator comes up with. It's essentially a mini trial. So you may think, well, why do people choose arbitration over a court system? There's a few advantages. One advantage is they can happen a lot faster. The arbitrator is basically the employee of the parties who are filing the lawsuit. Many times he's a retired judge, or she's an experienced attorney. So they don't have this backlog of cases that are going to delay the case that is going to be heard. And so it can happen a lot faster, sometimes in as little as 6 months. Another reason that this is a popular mechanism is that it can be handled confidentially. The press can be excluded, so there isn't necessarily a lot of publicity about the case if it's a high-profile case. Finally, there can be other cost savings. Even though usually there's some discovery, it can be curtailed, so it's not quite as expensive. And because there's no jury, usually the attorneys feel like they don't have to spend quite as much time preparing some of the more flashy aspects of the lawsuit. So it's quicker, it's more private, and it's usually less expensive. Those are some advantages to arbitration. But arbitration is not a perfect system by any means. Many people think that arbitrators are inclined to kind of split the baby, to kind of decide somewhere in between. So the plaintiff doesn't get everything that he wants, and the defendant doesn't get everything that she wants. And so there can be a concern if you feel like you've got a good case and that you'll just win flat out. You're probably not going to want arbitration, because usually you're not going to get everything that you want. At least that's the perception people have of arbitration. Now we're going to go through this last item on our to-do list. We talked about the anatomy of, and by the way, virtually everything that I said, in fact, I would say everything that I said would apply to any type of civil lawsuit. There wasn't really anything particularly unique about personal injury in that analysis. Now we're going to talk about our last topic in this chapter, which is responding to an accident, an incident, an emergency. What are we going to do under those circumstances? So let's go. And the textbook lists a variety of steps that are pretty smart, pretty good ideas to consider as you're developing your plan. Before we talk about the plan, it's important to have one. It's important for your staff to know about the plan and to know their particular role in the plan. And it's also important to practice the plan so that people, because when an emergency strikes, people are in a bit of shock. They can sometimes not function as clearly as maybe would be preferred. And so practicing, reminding, drilling can be very useful ways of getting a better response in an accident situation. So let's go through and consider what we want our employees to do, and also what we want our employees to avoid doing. The first step is, and obviously this isn't going to apply to every single case, but you do want to call 911 if there is a genuine emergency. We want to do that as soon as possible, even if we're not 100% sure that it merits that type of reaction. If we're unsure, err on the side of calling 911. That's usually going to be our first step. We want to attend to the injured person. We want to provide the assistance that we can, both emotional support assistance as well as medical assistance to that person. We want to be attentive to that person during the situation. Being attentive doesn't mean that we're claiming that we're responsible for it. That's just us being a decent human being to another human being. We want to be sensitive and sincere. We don't want to appear to be concerned about litigation at this point. That's not what we ought to be focused on. We ought to be focused on getting this person the best care that he or she can get under the circumstances. And we want to be showing legitimate and reasonable concern. Now, sometimes people get concerned, well, if I act like I'm concerned, that's going to imply that I think they're really badly hurt, or it's going to imply that I'm responsible for it. No, that doesn't follow. Genuine concern. I'm sorry that you're in pain. Can I get you something to help? That type of thing. Those are perfectly good things to do. They're positive things to do. But sometimes you can overdo sensitivity when it spills over into the apology area. You don't want to apologize. You don't want to apologize for anything. So saying things like, I'm sorry that you're in pain, that's perfectly fine. But saying, I'm sorry that Bob poured the soup into your lap, that's not a good thing to say. So saying or expressing regret that that person is in pain is always fine, but don't tie the distress or the pain to an action or inaction that your employees have done. So we don't want to apologize. And that's a good thing to practice because it's easy for people to accidentally fall into apology type language. Of course, related to that is you don't want to admit this isn't the time for those kinds of conversations. And that's a good approach to say. If somebody is getting in your face and saying, you caused this, you did this, say, let's get little Sally here, the medical care that she needs. This isn't the time for that conversation, ma'am. Let's focus on Sally. What does Sally need right now? How can I help right now? Focusing on that, moving away from the topic of who's responsible for it. That's rarely going to be a productive topic to have at the time of the accident. You do not want to offer to pay for medical expenses. Again, that can sound like an admission. The main thing is to get that person the medical expenses, the medical services that they need, and then at some later point we can figure out who's going to pay for that. So you don't want to deny assistance. Well, can you afford to pay for this? No, you want to make sure that the services are provided, and then at some later point we'll figure out the details, and that's a good approach. Let's get Sally the help that she needs now, and we'll figure out the details later on, that type of thing. Don't mention insurance coverage. Again, those words can be very appealing to a person who's been injured. They've got insurance. You don't want to predict how your insurance company would handle a particular situation, or whether your coverage it covers this particular category thing. So you want to avoid that. You want to avoid discussion about how the accident was caused. Again, you're focusing upon giving aid and assistance to the person that's injured. It's a discussion for another day how this person became injured. It may be under the circumstances that it's pretty obvious that somebody did something wrong. Again, if Bob did actually spill this hot soup on Sally's lap, probably it's not very controversial that Bob is responsible for that. But you don't want to correct that employee at the scene. You don't want to do it in the presence of the people who are potentially suing. That's better to handle that topic later on. For one thing, we're focusing upon helping little Sally or whomever the person is. To correct the other person at that moment is going to be a distraction. It's also possibly going to increase kind of the emotion of that particular circumstance. And it's going to be hard for you to argue that Bob didn't cause the accident after you've corrected them at the scene. Also, it's always a good idea to approach employee discipline in a confidential way. Even if you're going to ultimately dismiss Bob, you want to handle that in a way that's sensitive to him, because even if you don't really care about Bob, the other employees are going to see how you act with Bob, and they're going to draw some conclusions about how you'll treat them. And so you want to be respectful of Bob, if for no other reason than others are watching. So do that to kind of discipline, not at that particular time. Okay, so the first 9 steps are really in the moment when the situation is happening. And you can see there's a lot of do nots. And then we get to step 10. This is where we start talking about what's going to happen after the ambulance has gone away. And you want to do a complete and thorough investigation. Very likely you're going to want to interview people who were present. You're going to want to inspect the things that the physical things that might have affected how things played out. You'll also want to do a claim report and submit it to your insurance company as quickly as possible. You're going to do this even if the person hasn't indicated that they are going to file a claim or whatever. So you don't mention insurance, but you are going to be working under the assumption insurance may be applicable. Sometimes if you don't file your claim soon enough, you may find that you're not going to have coverage that you would have otherwise had. Let's go to step 12. You should not discuss the accident or the investigation with anybody except those who need to know. When you're investigating it, you are hearing what people have to say. You're not going to go back and say, well, this is what I think or whatever. You're gathering data. You're not going to share that data outside of the chain of command within the organization. It may be necessary that you talk with the insurance company or perhaps the police, but you want to be very cautious about going beyond those points of contact, because again, loose lips sink ships. The person you're talking to today may suddenly be talking to the plaintiff's attorney tomorrow. You absolutely don't want to throw away anything that may be evidence in the case. If you throw it away and it would have been useful in the case, you can get what's called a spoliation charge. And under those circumstances, the plaintiff will be able to tell the jury, and the judge will in fact tell the jury, that you should assume whatever it was that was destroyed would have hurt the defendant's case and would have helped the plaintiff's case, because otherwise why would the defendant have destroyed it? And yet you might have destroyed it simply because it was dirty. Maybe it was a tablecloth that got blood on it. Well, you might have thought, gosh, I don't want this tablecloth with blood on it. But if you throw it out, then you might be charged with spoliation. It's very difficult to win a case when there is significant evidence that's been spoliated or destroyed. So that's our overview. Now, as you can, going back to this list, you can see that especially a lot of the action here is going to be step 2. What does it mean to attend to the injured party? This could be CPR. This could be other tasks. So it can be, depending upon the nature of your business, you may want to have a lot more specificity here. Also, the staffing that you have. You may have a loss prevention or security function within your facility, and so they might be the people who take the lead here. In a smaller organization, you might be having the manager do many of these tasks. So you'll want to think through who these people are going to be and what roles they might have. And you'll probably want to have somebody who's kind of directing traffic. So, you might say, if you are the manager on duty, Sally, you call 911. Bob, you clear this area from people walking around. Sally, you get the first aid kit. All those things you might start pointing to people to deliver. Well, you want Sally to know where the first aid kit is. You want whomever you're sending to do that to be able to do that as efficiently as possible and as calmly as possible. So now we have covered all of the topics that we have in this particular chapter. We have covered the duties and obligations of a hospitality operator. We've covered the theories of liability. We've discussed legal damages. We've discussed the anatomy of a lawsuit, particularly a personal liability lawsuit, and we talked about some strategies for responding to an incident that has arisen. So we've concluded the topics for this chapter. As always, if you have questions, don't hesitate to email me. I always like to hear from students. And also, you're welcome to come by and see me during my office hours. I'd be glad to meet with you to discuss the material in more detail if you have questions. As always, I thank you for your attention, and I hope you have a wonderful day.